has no authority to add on to the Constitution in such a way that would take away rights previously guaranteed. What seems to be Mr. McCollum's problem? Does he not read the King's English? Excuse me. Simply spoken, he has no authority to pass this 666 bill. The Congress had no authority to pass this Brady bill. They had no authority to pass this crime bill because it clearly infringed on the United States Constitution. I don't care how noble the issue it was. I don't care how learned the people claim to be. They weren't learned enough. Because if they were learned, they would have understood the 9th Amendment forbids adding on to the Constitution by any laws whatsoever that takes away rights that are previously guaranteed. Excuse me. Now, let's go on. Let's hit the 10th Amendment. The powers not delegated to the United States. What are they talking about here? The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. See, this is a limited contract. This contract is designed to limit government. And when you get into your police powers, you start understanding your police powers. Almost you'll hear this all the time. Well, we have police powers. Broad and sweeping police powers. You look up Black's Law Dictionary of Police Powers. It says, the law of eminent domain of a state or political subdivision to enact laws for the common good and welfare and to curb crime. And in great big black letters it says, within constitutional limitations. See the 10th Amendment. Well, when they're talking about see the 10th Amendment, this is the 10th Amendment they're talking about. Now, do they have powers to take away previous rights guaranteed under the Constitution? The answer is obviously no, they don't. Obviously, the 9th Amendment sets a clear limit on that. What is it these guys don't understand about their Constitution? They pass these Brady bills, they pass these crime bills, they pass these 666 bills to take away your 4th Amendment right, requiring a search warrant. What is it that they don't understand about the locks on the Constitution? Now, do you see how wise our forefathers were? They knew history, and they knew that history repeats itself if people forget. So what they did is they set a standard, very importantly, toward the end of the contract that clearly stipulated exactly what limits would be there, you see. And it clearly stipulated that no power has existed to take away rights that were previously guaranteed. So how, therefore, is this being done? I'll tell you how it's being done, because they wants to. And they're not doing it by law. Now, why are they getting away with it? Because most of the people don't know any better. And if you don't know your rights and you don't timely assert them, laches and curs. Laches being a species of action wherein a party of reasonable intelligence and integrity having a right to take an action as is prescribed by law, and having failed to timely do so, loses all right to proceed. So, by you acquiescing, by not jumping up and saying, hey, hold the line, Chester. You ain't touching that 4th Amendment. You aren't touching that 2nd Amendment. We're not putting up with that stuff. You took an oath of office, we're going to hold you to it. You violate that oath of office, we're going to charge you with capital felony treason under Title 18 United States Code Section 2381. What difference does it make if they're in open rebellion against the United States or if they're breaking down the laws creating a rebellion? Isn't that giving aid and comfort to the enemies of our country? It most certainly is. And it's called sedition. Treason by sedition. Okay? Now we got to start collaring these guys and telling them, hey, what is it you don't understand about the Constitution and your oath of office? We're going to clearly correct that in the short interim. And if you don't want to fix it, we will remove you. And that's our duty and our responsibility. Now, when Benjamin Franklin walked out of all of the hearings to set up this Constitution, a lady reporter walked up to him and asked him, what is it we have now? And he turned to her and told her, we have a republic if we can keep it. Obviously, the burden is on us to make sure we keep it. So I'm asking you to get a hold of one of these constitutions and let's plan on keeping it. Alright, now let's get into some more of the arguments on the Constitution. Your 5th Amendment. Let's pull up your 5th Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on the presentment or indictment of a grand jury except in cases arising in the land or naval forces or in the militia, when in actual service in time of war, or public danger, nor shall any person be subject to the same offense be twice put in jeopardy, that's the double jeopardy statute, of life or limb, nor shall be compelled in any crime criminal case to be a witness against himself. That's a self-incrimination defense. Nor be deprived of life, liberty, or property without due process of law. That's your equal protection clause. You have an equal right to all of your rights under the law, and you have a right to due process of law. Matter of fact, if they don't give you due process of law, Title 5 United States Code, Section 556D, is clear and specific, and it says if they deny you due process of the law, all jurisdiction ceases automatically. That's Title 5 United States Code, Section 556D, also 557, and Section 706 of that code. In other words, if they deny you due process at any time and you can prove it, you can force a showdown, and you can turn around and say, well, they might have had jurisdiction at one time, Judge, but they lost it when they denied me due process. Alright? Now, the other parts are you cannot deny him life, liberty, property without due process of law, nor shall private property be taken for public use without just compensation. You know, how many times do you hear about that today? I mean, it's incredible. The Sixth Amendment is another important one. All of them are important, but there are more important ones, alright? In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and the cause of the action and accusation, to be confronted with the witnesses against him. That's the right to confront your accusers. To have compulsory process for obtaining witnesses in your favor. That's the subpoena rights. And to have the assistance of counsel for your defense, or you can stand as your own counsel. And I know they tell you that it's a fool that stands as his own counsel, but it's my argument that it's a fool that doesn't. Because I'll tell you why. You know your case better than anybody. How many times do you hear about gripes between attorneys and the citizens? The biggest gripe they have was, well, he never said nothing about that, or she never said nothing about that. Well, she didn't do this, or she didn't do that. Well, why? Because they don't know the case as good as you do. You're the one that knows your best case. The only thing they know is how to apply the law. So all I'm telling you is learn how to apply the law and your constitutional rights, and then you don't need to do that. The only time you get into trouble is if you run your mouth too much and you get into self-incrimination. So obviously you have to keep your wits about you and watch your mouth. But the bottom line is, actually, I personally believe you're the best person to present the facts of your case, because you're the best person that knows all the facts. The only thing you know how to do is how to actually do it in a legal and lawful manner that is recognized by the legal community. And that's really not hard to learn. I can teach you, believe me. Alright, the Seventh Amendment. In suits at the common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. It's supposed to say shall remain. And no fact tried by a jury shall be otherwise re-examined in any court of the United States, because the jury is the ultimate trier of fact. Then according to the rules of the common law. Now, we'll get into that common law argument. There's a lot of heavy arguments around that common law. Basically, I don't want to overwhelm you on the first time out of the chute. Because that's not hard to do, okay? Now, the bottom line of this Constitution is it's all in writing. It clearly represents a contract. I'm asking you to learn your contract. I'm asking you to learn the book. Learn your contract. I mean, when you go to some place to do some work on your car, you read the document that comes with it for the warranty, don't you? Why? Because just in case something goes wrong, you want to be able to bring it back, right? Well, I'm asking you to read the warranty on your Constitution so that you can understand the rights that you have under that Constitution. So that if you don't get it right, we can bring it back. Does that make sense to you? Alright. Now, it's also important that you understand that this Constitution is a very unique document, and that this Constitution is supposed to be enforced, and I'm going to teach you some things here right now. This is a program, I don't know how it's coming out here. This right here is representation. I know it's kind of hard to see here, but basically what we're talking about here is this comes from the books that tell the judge how, right here and over here, this comes and tells the judge how the Constitution is to be interpreted. This is from the Am Jurisprudence volumes, and this is volume 16. You want the Constitutional Law section right here, Constitutional Law, and you want section 97. And when you start reading it, the most important part about it, and I'll read it, is that a Constitution should receive a liberal interpretation in favor of the citizen is especially true with